Is there a message of necessity at the desk? There is a message of necessity at the desk. Move to accept the message of necessity. The message is accepted.
Hello, and welcome to another episode of Messages of Necessity. My name is Kyle Davis. I am the Director of Public Affairs at the Empire Center, and I get to sit down with Senior Fellow Cam MacDonald to discuss some legal issues. How are you doing today, Cam?
I'm doing great. Thanks.
So, Cam, you have a couple recent blog posts that we're going to touch on today, dive into some of the details around one on the ERA or Prop 1, and then also another one on squatters' rights. Specifically, the first one, the one on Proposition 1, you wrote a blog post probably about a week ago now saying that the rule of law was upheld by the court taking the decision that it did. Do you want to dive in and give some of the facts around that case to begin with?
Sure. So I guess I'll start with the rule of law and what it means, and that's that generally to have a civil society, you want laws that are written down and clear and transparently passed, and then impartially enforced by a judiciary, our courts. And so in this instance, what happened was the Constitution, Article 19, Section 1 of the Constitution, has one of the methods of amending our Constitution, which is that the legislature can pass a joint resolution of the Senate and the Assembly with a proposed amendment that then is passed the law that must be passed in one legislative session and then put on notice to the public for 3 months before a general election and a new legislature is voted in. And then the next legislative session, it's voted on again. One of the conditions, though, too, is that once the resolution is first introduced, it is supposed to be referred to the Attorney General for an opinion on how it combines with or potentially conflicts with other provisions of the Constitution. And the Attorney General is given 20 days to come up with that opinion before there's to be a vote held by the legislature.
What were the main procedural errors committed by the legislature in this case? You mentioned the Attorney General's opinion. It kind of gets hung up there, right?
Yeah, so what happened was, you may recall that in 2022, June of 2022, there were some landmark decisions that came down from the United States Supreme Court. There was the one involving New York itself with the Bruin decision on Second Amendment rights and concealed carry licensing, and then I believe it was followed by or preceded by the Dobbs decision on abortion that overturned Roe v. Wade. So what happened was those decisions came down in late June, and on July 1st, there was an extraordinary session of the legislature called, and the governor issued a message of necessity for passing some laws for gun control laws in response to Bruin. It was a hurried thing, as you may well know. Some parts of the law were ruled unconstitutional by the district court, and I think there was an injunction that's been upheld at the Second Circuit on some of that, and the legislature has gone back to the drawing board on some elements of the law to change its provisions. So it was a rushed sort of thing. The response on the abortion issue was this, what they call an equal rights amendment. It's going to be Proposition 1, that was scheduled to be Proposition 1 on the ballot. And it was an attempt to add a bunch of categories of persons to the Equal Protection Clause of the state constitution. As you probably know, abortion rights. Abortion was addressed several years ago during the Cuomo administration, where it was ensconced into law that basically abortions are okay through full term in New York State.
So the specific case that was brought before the appellate division was Burns versus the Senate of New York, What do you think is the significance of that specific case, in your opinion? How does it fit into this broader legal landscape that you're
Yeah.
drawing on right now?
So what happened was the legislature skipped a step when it passed. So on that day of July 1st, this Equal Rights Amendment resolution was put on the table and hours later voted on by the legislature. That same day, they sent the resolution for the Attorney General's opinion, and they were supposed to have waited the 20 days, which obviously they did not because they voted on the same day that they introduced it. And so what the court in Livingston County has determined was they didn't follow the procedure under the Constitution, that there was a reason for it. It's there in order to have an informed and deliberative process about something as important as putting a constitutional amendment before the voters, and they skip that step. You don't get to skip that step. Now, one of the counter arguments from the legislature and the state is that there is a part of the there is a provision in the Constitution that says that you don't need to have that opinion basically if you wait the 20 days. So if the Attorney General refuses to give an opinion or gives an opinion after the 20-day deadline, that does not negate a vote to approve the resolution after the 20 days have expired. It's essentially built into so not to give that one statewide elected official what's called by some a pocket veto. So the Attorney General can't just deep six the amendment by not doing anything on it or playing games with the timelines.
So rather than the legislature sitting on it and waiting for the Attorney General's opinion to come out, the course of action, according to this Livingston County judge, would be that it should have been on the ballot previously rather than them holding it and putting it on the ballot in 2024.
No. What the Livingston County judge says is the process you went through made the resolution invalid because you did not introduce it, wait 20 days to get the Attorney General's opinion, and then vote on it. So what they should have done is on July 1st, they gave it to the Attorney General. Sometime after July 21st, voted on the resolution. Then it would have had the 3 months of time. They had up until August 7th to vote, to get 3 months notice before the general election that year in 2022. And they did not do all that. What you are talking about is the fact that they rushed to get this amendment done in that legislative session before the general election, and then they did not introduce they introduced it again then in January of 2023 when the new legislature was sworn in and back, but then they did not put it on the 2023 ballot. They waited for 2024, and I think critics of the amendment would say they cynically did that when they thought there would be higher turnout during the presidential election year as opposed to an off year like the 2023 elections.
So some of our audience may not be familiar with the process that proposition should take in order to become on the ballot and also get voted on, be put into the New York State Constitution. Can you draw out from a bird's eye view, from a 1,000-foot view, what the process should be for a constitutional amendment in New York State?
Well, it should be just that. So let's say, for instance, so as of today, the Attorney General has appealed the decision of the Livingston County judge. That's now going to be on appeal at the appellate division and probably to the Court of Appeals and possibly on some rapid time frame so that the proposition could stay on the ballot for this fall. But what they could do is they could today introduce a resolution with a proposed amendment that maybe is thought through a little bit better, refer it to the Attorney General for an opinion, and come back in 3 weeks and vote on it, and then vote on it again next year after this general election and put it on the 2025 ballot. So instead, it looks like they're going to try to play this out in the courts and see what kind of result they can get in the courts rather than handling it in this legislative session and the one that follows next year.
So your opinion is the legislature isn't going to act, but the courts are going to be the ones that ultimately make a decision on what happens to Prop 1?
I don't know. I don't know what the legislature might do. Clearly, the Attorney General has been directed to pursue an appeal by her clients, which are the Senate and the Assembly. So that would seem to indicate that they are going to take their chances on playing this out in the courts, as opposed to, um, putting this on the ballot again in 2025 with either the same or an improved amendment.
So speaking of the end of session, you recently gave an incomplete grade to the legislature's attempt to address the squatting problem in New York. It's something that has been all over the news. Why did you do that, Cam?
Yeah, so when I looked into the issue when squatting, I don't know how prevalent squatting is, but it's certainly gotten a lot of attention, and it got a lot of attention of legislators, and there were some battling bills for addressing squatting in New York, and it just wasn't clear what was going on with why people couldn't get squatters out of their properties. And so I looked into it, and what ended up happening was that the big ugly of the budget bills, I believe, had a provision to address squatting, but what it really all did was define what a squatter is, or what squatting is, which means you're, somebody that's uninvited there without permission, occupying somebody's uh, property. Um, so I looked at how the courts have handled this in the past, and it appears that the courts have never had any problem understanding who a squatter is and what a squatter's rights are. So there was not really any misunderstanding. The key words were you were either a tenant or you were somebody who was a lawful occupant of the place, and you would have particular rights. There was some confusion in the media accounts and people's descriptions of it, where people believe that if you were in a place for more than 30 days, you had some sort of tenant rights, which has just never been the case. So I quoted some cases, cited some cases in my blog post about the fact that the courts had just never really been confused about who is a squatter and who isn't a squatter, and that property owners do have rights that they can exercise to get rid of squatters that don't require them to go to court.
So would you say that the misconceptions weren't so much legal misconceptions in the courts, but maybe public misconceptions about what squatting was and what rights they would have?
Yeah, I think there was just a public misconception about what rights squatters have, and I think it may get confused by the fact that I don't have personal experience with being in the courts, especially in New York City, where there seems to be a lot of landlord-tenants disputes bogged down. But the bottom line is you can self-help evict a squatter, which means you can do the traditional things like go and change the locks and that sort of thing. You can enlist the police to come help remove order the trespassers out, or even have them arrested. Some of this news accounts seem to indicate that there were some confusing circumstances about why people were occupying places where you could see that the police would be reluctant to get involved. And landlords, do have potential liability if they are found to have unlawfully evicted someone. So the prudent course for most people would be to go to court to get an eviction warrant from a court, or to go to a government agency that might have authority to give you an eviction order, a vacate order. But so then the problem probably is in landlords needing to go, or property owners needing to go to courts where they get bogged down in a long legal process. As I pointed out in my piece, in recent years, as part of the various tenant protections, the legislatures kind of lengthened the time for the notice to the person of the proceeding. They've lengthened the time to respond to your petition to the court, and they have granted an automatic adjournment by the request of any party at the first hearing. And that can typically be if it's from a squatter or a tenant, for the fact that they need to find legal representation, for instance. And so I don't really particularly know what causes major delays in the courts other than the pandemic. The created a huge backlog of cases because evictions were not allowed during a certain period during the COVID-19 pandemic under emergency orders. And so they've been working through some major backlogs, and there just may not be the personnel available or the administrative will to keep these cases moving along in the courts.
So yeah, so it sounds like from your perspective that this is more of a government efficiency problem than necessarily there being something wrong in the statute to begin with.
Yeah, I think it probably lies in property owners needing to get better assistance from the police, and maybe there's I think I did cite a bill in my piece that was that's been introduced that kind of provides a process or a procedure or kind of a sworn statement developing all the elements that the police would need to believe the property owner has squatters in place, that the person would do under perjury and, recognizing they might be subject to damages. But there's landlords needing or property owners needing to know what their rights are when it comes to self-help evictions, potentially getting better assistance from the police, or the court system being more efficient so that people can do the more prudent thing, which is to go get an order from the court that they can get the sheriff to help them with.
Cam, is there anything else that you would want to say on either the squatters or the ERA? Is there anything that stands out that the public and our audience should be aware of?
I guess they should stay tuned to what's going on with Proposition 1 with the courts, and then if the courts are going to order it back on the ballot, to look closely at what kind of legal reasoning is behind that. I don't see how an appellate court should go the other way, but I've been proven wrong in the past. And then know what that's going to entail. So pay attention to just what they're voting for or against in the fall. And then with the, if you do believe that squatting is an issue, let your legislator know that whatever was done in the budget process wasn't enough to fix the problem, and so that there might need to be some other sort of legislative solution. So the bill I was mentioning is the one that's by Senator Mario Matera and Assemblyman Steve Cern. They have the separate bills with that process for getting enlisting the police help from the police for evictions.
I would like to thank everyone for tuning into this episode of Messages of Necessity. You were able to get 2 podcasts for one in this episode. Cam, I would like to thank you for taking the time to speak to these issues, and until next time.
It's always my pleasure.
For more news and analysis, visit our website and sign up for email updates at empirecenter.org. Follow us on Twitter, Facebook, and LinkedIn at Empire Center.